Public Bills, second reading.
Honourable Attorney General.
Mr. Deputy Speaker, I move that the Revenue Tribunal Bill number 12 of 2025 be read a second time.
Seconded.
Mr. Deputy Speaker, I shall keep my remarks short and focused. This bill aims neither to widen tax powers nor to invent new causes of action. It does one thing only. It replaces the Assessment Review Committee, currently provided for in Section 18 of the Mauritius Revenue Authority Act, with a Revenue Tribunal, and this with a clear purpose in mind, rationalizing and modernizing the process with the necessary checks and balances in order to have a more just, accessible, and comprehensive system. That shift may look modest on paper, yet it answers concrete shortcomings that practice has made impossible to ignore. I will outline those shortcomings, explain how the bill deals with each, and show why a new legislation instead of simple amendments was the only satisfactory route. The Assessment Review Committee, Mr. Deputy Speaker, sir, created in 2006, has indeed performed valuable service. Its composition placed experienced barristers in the chair and paired them with members drawn from accountancy, economics, and taxation. It could sit in flexible panels, and from 2022, it even gained power, subject to the consent of the parties, to reconstitute a panel that lost one of its members before the case is over. None of that is being discarded. The new tribunal still has the Public Service Commission as appointing authority for its legal members and preserves the requirement that lay members bring specialized financial expertise and remain independent of the public service or the MRA. But we needed to go further. Experience has revealed 4 structural obstacles which the existing committee, because of its very nature as an emanation of the MRA's statute, could not overcome. First, institutional independence. The main function of the Assessment Review Committee is to hear and determine representations made by any person who is aggrieved by a decision, determination, notice or claim of the Director-General of the MRA or of the Registrar-General. However autonomous and unbiased the Assessment Review Committee may be, it remains conceptually part of the authority whose decision it reviews. Therefore, in view of the quasi-judicial nature of its functions, it is considered more appropriate for such functions to be discharged by a fully fledged tribunal along the same lines as other existing administrative tribunals, such as the Employment Relations Tribunal, the Environment and Land Use Appeal Tribunal, and the Public Bodies Appeal Tribunal. The Revenue Tribunal will be a standalone body, established by its own act, with its own secretary and staff working under the chairperson's administrative control. That separation is not cosmetic. It speaks to public confidence, particularly among foreign investors accustomed to seeing revenue disputes being handled outside the revenue agency's statutory framework. It puts the new tribunal at par with other quasi-judicial bodies, which I referred to earlier, which are entrenched in the minds of the citizens as checks and balances to the exercise of executive power. Second, procedural certainty. Per Section 20, subsection 3 of the MRA Act, the committee, the ARC, endeavored to fix hearings within 3 months and to issue its decisions within 6. Such good intentions too often slipped, sometimes because complex interlocutory matters consumed the calendar. The bill transforms these aspirations into legal obligation. Clause 7 now mandatorily requires the tribunal to schedule a preliminary hearing within 120 days of lodging and deliver its determination within 90 days of the close of evidence. a period which may be extended only in exceptional circumstances and only with the consent of all parties. The timelines are thus shorter, clearer, and enforceable, and practitioners will be free to plan and taxpayers budget around a reliable procedural calendar. Third, the scope of appeals. Under the present Act, a party dissatisfied with the decision of the ARC may go to the Supreme Court only on a question of law, via an outdated process of asking the ARC to state a case. That narrow gateway means that an error of fact, for example, an arithmetical slip or a mistaken reading of a ledger, cannot be corrected on appeal. Clause 1 removes that artificial constraint. Appeals will follow the ordinary civil route used for district court judgments, allowing the Supreme Court to examine both fact and law. The change neither widens nor narrows tax liabilities. It simply ensures that mistakes in the appreciation of facts of whatever nature may be rectified. Accordingly, an appeal to the Supreme Court will now also be assessed on any factual evidence adduced before the Revenue Tribunal. Fourth, alternative dispute resolution. The current system relied on separate alternative tax dispute resolution panels. Those panels have been now repealed, and the bill closes the gap by weaving mediation into the tribunal's own fabric, where both parties ask for it. The chairperson will refer the matter to a mediation panel consisting of a legal member of the tribunal and, where appropriate, another member. Any agreement reached will be recorded as a final, binding determination, and if none is reached within 90 days, the case reverts to the tribunal without prejudice. The taxpayer therefore gains a voluntary, confidential avenue that can conserve both resources and goodwill. This bill also codifies matters that until now depended on implication or practice. Clause 9 states expressly that the burden of proving that an assessment is wrong or that a tax has in fact been paid lies on the person disputing the charge. Clause 12 creates specific offences for refusing to attend or for giving false evidence, with penalties of up to 100,000 rupees and imprisonment. Those provisions do not invent new duties. They place existing judicial expectations beyond doubt. Conversely, the bill abandons what is no longer needed. The key performance indicator regime, whereby the Minister of Finance, sets annual targets for the committee, is not reproduced. The independence of the tribunal means that it must enjoy freedom from ministerial control and notation, subject to the requirements of the legislation. And a word on transition now, Mr. Deputy Speaker, sir. Clause 18 provides that every matter already opened before the committee as it stands today and still pending on commencement day of this legislation will be taken over by the tribunal exactly where it stood at the time. Parties will not have to free file, and fees already paid will be carried forward. In short, no litigant will be disadvantaged by the structural changes. Mr. Deputy Speaker, sir, to recap in broad strokes, this bill contains 4 clusters of clauses. First, the machinery itself, clauses 1 and 2, supply the preliminaries. Clauses 3 and 5, 3 to 5 create the tribunal, set its membership and staffing. Second cluster, the hearing process, clauses 6 to 10, preserve the 28-day appeal window, lay down full procedural instructions with firm timelines, take evidence on oath unlike before the ARC, build in mediation, place the burden of proof on the appellant, and spell out the tribunal's power to confirm, amend, or quash a revenue decision. Third cluster, supervision and enforcement. Clause 11 opens appeals on fact and law to the Supreme Court. Clauses 12 and 13 set offences for obstruction and give members statutory immunity, whilst Clause 14 and 15 authorize regulations and rules of court. Finally, the fourth cluster, consequential matters. Clause 16 repeals the ARC from the MRA Act. Clause 17 updates 10 related enactments. Clause 18 moves pending ARC cases straight to the new tribunal. Clause 19 deals with commencement, and the schedule lists every revenue law that will now fall within the tribunal's reach. Mr. Deputy Speaker, sir, fair taxation implies fair adjudication. The design before the House retained what has worked: a professional bench, specialized members, flexible panels. And it corrects what has not worked: institutional dependence, elastic timelines, an unduly narrow right of appeal, and the absence of a modern mediation track. It does so through an instrument that does not make the tribunal a subsidiary of the authority it reviews. That is the entire logic of the bill. It is a small step in the vast modernization process which we are bringing to consecrate the rule of law and make justice more accessible and efficient. Mr. Deputy Speaker, sir, after the bill was introduced to this House, we received some further proposals from members of the Assessment Review Committee, some of which have been taken on board and some of which we did not, as we deemed them superfluous. They are mainly with regard to some cross-referencing in other legislation and to bring clarity in some provisions of the bill. We have already circulated the amendments, which are only technical in nature, and I will move for these amendments at committee stage of the bill. With these words, Mr. Deputy Speaker, sir, I commend the Revenue Tribunal Bill to the House.
Thank you.